See, the case of Salinas v. Texas starts with Mr. Salinas being questioned by police. Petitioner, without being placed in custody or receiving Miranda warnings, voluntarily answered some of a police officer's questions about a murder, but fell silent when asked whether ballistic testing would match his shotgun to shell casings found at the scene of the crime. At Petitioner's murder trial in Texas State Court, and over his objections, the prosecution used his failure to answer the question as evidence of guilt. He was convicted, and both the State Court of Appeals and the Court of Criminal Appeals affirmed, rejecting his claim that the prosecution's use of his silence in its case in chief violated the Fifth Amendment. In the Salinas case, it wasn't a question of whether or not what he said could be admitted as evidence in the court of law. Rather, whether his silence was evidence of guilt. Now, this abuse of the Fifth Amendment was upheld by a 5-4 decision by the Supreme Court, the opinion for which was written by Justice Alito. To prevent the privilege against self-incrimination from shielding information not properly within its scope, a witness who desires the protection of the privilege must claim it at the time he relies on it. Here again, we see the illiteracy often demonstrated by the courts. First, what's at issue is not a privilege, it's a right to immunity. The court is not required to give you silence, they just cannot force you to speak. Second, this right has nothing to do with self-incrimination, but with self-witness. If you don't wish to divulge information about yourself that has no incriminating value, that is your right, protected by the Fifth Amendment to the Constitution of the United States. Apparently, this fact is lost on at least 5 of the 9 justices of the Supreme Court. Now, the court compounded this error when Justice Alito wrote, "Petitioner's silence falls outside this exception because he had no comparable unqualified right not to speak during his police interview." Apparently, these justices were absent in law school when they taught about the First Amendment. Oh wait, law schools don't teach the actual Constitution anymore. Otherwise, the justices would have remembered the First Amendment and Congress shall make no law abridging the freedom of speech. You see, freedom of speech is not only the right to speak, but the right to refrain from speaking. So, contrary to Mr. Alito's position, Mr. Salinas retained the right not to speak and not to witness against himself during his police interview. Now, I don't know if Congress has passed legislation requiring people to speak to law enforcement, but if they did, it's unconstitutional and therefore void, and the courts are bound to ignore it. From Marbury versus Madison, thus the particular phraseology of the Constitution of the United States confirms and strengthens the principle supposed to be essential to all written constitutions, that a law repugnant to the Constitution is void, and that courts, as well as other departments, are bound by that instrument. If Congress has not passed such legislation, then Justices Alito, Roberts, Kennedy, Thomas, and Scalia violated their oaths of office by placing their own opinions above the law of the land.